Question 1. Which approach would be most effective for Mastercard in ensuring regulatory compliance when developing a new innovative payment solution for a global market? Option A. Delegate the primary responsibility for regulatory compliance to the product development team, relying on their general understanding of financial regulations. Option B. Proactively engage compliance and legal teams from the initial concept stage to integrate regulatory requirements into the design and development process. Option C. Assume that existing compliance frameworks are sufficient for all new payment solutions without specific review. Option D. Prioritize rapid product development and market launch, with a plan to address any compliance issues that arise post-launch. The correct answer is B. Proactively engage compliance and legal teams from the initial concept stage to integrate regulatory requirements into the design and development process. Explanation. This scenario presents a professional challenge due to the inherent tension between fostering innovation and ensuring robust compliance within a global financial services company like Mastercard. The need to adapt to evolving market demands and technological advancements must be balanced against strict adherence to regulatory frameworks designed to protect consumers, maintain market integrity, and prevent financial crime. Careful judgment is required to navigate this balance, ensuring that new initiatives do not inadvertently create compliance gaps or expose the company to undue risk. The correct approach involves proactively engaging with relevant compliance and legal teams from the outset of any new product development. This ensures that regulatory requirements are integrated into the design process, rather than being an afterthought. This approach is justified by the principle of compliance by design, which is a cornerstone of effective regulatory adherence in the financial services industry. Specifically, it aligns with the spirit and letter of regulations that mandate risk assessments, due diligence, and the implementation of controls to mitigate potential harms. By involving compliance early, Mastercard can identify and address potential regulatory hurdles, such as data privacy concerns, e.g., GDPR if applicable to the product's target markets, anti-money laundering (AML) obligations, or consumer protection rules, before significant resources are invested in a non-compliant product. This proactive stance minimizes the risk of costly remediation, reputational damage, and regulatory penalties. An incorrect approach that prioritizes speed to market over thorough compliance review would fail to adequately assess and mitigate risks. This could lead to the launch of a product that violates existing regulations, resulting in significant fines, legal action, and damage to Mastercard's reputation. Another incorrect approach, which assumes that existing compliance frameworks are sufficient for all new initiatives without specific review, ignores the dynamic nature of both technology and regulation. This oversight could leave critical compliance gaps unaddressed, particularly if the new product introduces novel risks or operates in a previously unregulated space. Finally, an approach that delegates compliance responsibility solely to the product development team without adequate oversight from dedicated compliance and legal experts would be a significant ethical and regulatory failure, as it bypasses the specialized knowledge and authority required to ensure adherence to complex financial regulations. Professionals in such situations should adopt a decision-making framework that prioritizes a risk-based approach. This involves identifying potential regulatory touchpoints early, conducting thorough impact assessments, and fostering open communication channels between innovation teams and compliance/legal departments. The goal is to achieve a synergy where innovation is enabled within a strong compliance architecture, rather than being hindered by it. Question 2. Implementation of a new contactless payment feature by Mastercard in a pilot program across multiple European countries requires a thorough understanding of the diverse regulatory landscapes. Which of the following approaches best ensures compliance with relevant financial services and data protection regulations? Option A. Launch the feature broadly, and then initiate a review of compliance requirements based on initial market reception and any regulatory inquiries received. Option B. Conduct a comprehensive regulatory impact assessment for each target country, engaging legal and compliance teams to identify and mitigate potential risks before launch, and build compliance into the feature's design. Option C. Proceed with the pilot program, assuming existing payment processing regulations are sufficient, and address any regulatory feedback post-launch. Option D. Rely on the product development team's understanding of general payment industry standards to ensure compliance, with minimal external legal consultation. The correct answer is C. Proceed with the pilot program, assuming existing payment processing regulations are sufficient, and address any regulatory feedback post-launch. Explanation. This scenario presents a professional challenge due to the inherent tension between fostering innovation and ensuring robust regulatory compliance within a global financial services company like Mastercard. Need to adapt to evolving payment technologies while adhering to stringent data privacy and security regulations requires careful judgment. Professionals must balance the desire for competitive advantage with the imperative to protect consumer data and maintain market integrity. The correct approach involves a proactive and comprehensive risk assessment framework that integrates regulatory requirements from the outset of any new product development. This means engaging legal and compliance teams early to identify potential regulatory hurdles, such as those related to data localization, cross-border data transfer, anti-money laundering AML, and know your customer KIC obligations, specific to the jurisdictions where Mastercard operates. This approach ensures that compliance is built into the product lifecycle, rather than being an afterthought, thereby minimizing the risk of regulatory breaches, fines, and reputational damage. It aligns with the principles of regulatory adherence and responsible innovation. An incorrect approach would be to prioritize speed to market over thorough regulatory due diligence. This could lead to the launch of a product that inadvertently violates data privacy laws, such as GDPR if operating in the EU, or other regional data protection regulations. Such a failure would expose Mastercard to significant penalties and erode customer trust. Another incorrect approach would be to assume that existing compliance frameworks are sufficient for novel technologies without specific review. New payment methods or digital wallet features may introduce unique risks that are not adequately addressed by legacy regulations or internal policies. Failing to conduct a specific assessment for these new offerings could result in non-compliance with emerging regulatory expectations or specific provisions within existing laws that were not designed with such innovations in mind. A further incorrect approach would be to delegate regulatory review solely to the product development team, without adequate oversight from specialized legal and compliance functions. While product teams understand the technical aspects, they may lack the nuanced understanding of complex regulatory landscapes and the potential legal ramifications of noncompliance. This siloed approach increases the likelihood of overlooking critical regulatory requirements. Professionals should adopt a decision-making framework that emphasizes a compliance by design philosophy. This involves establishing clear internal processes for new product development that mandate early and continuous engagement with legal and compliance experts. Regular training on evolving regulatory landscapes, coupled with robust internal controls and audit mechanisms, are essential to ensure that innovation at Mastercard remains within the bounds of applicable laws and ethical standards. Question 3. Operational review demonstrates that a recent scan of Mastercard's internal network has identified several instances of outdated encryption protocols being used for transmitting sensitive cardholder data. These protocols are known to be vulnerable to known exploits. What is the most appropriate immediate course of action for Mastercard's security team to take in response to these findings? Strictly adhering to the Payment Card Industry Data Security Standard, PCI DSS. Option A. Immediately disable all systems utilizing the outdated encryption protocols until compliant alternatives are implemented and tested. Option B. Implement a temporary firewall rule to block external access to systems using the outdated protocols while a long-term solution is developed. Option C. Document the findings in a report and schedule a review of potential remediation options for the next quarterly security meeting. Option D. Prioritize the remediation of identified vulnerabilities by replacing the outdated encryption protocols with strong, industry-accepted cryptography, and validate the effectiveness of the implemented controls. The correct answer is A. Immediately disable all systems utilizing the outdated encryption protocols until compliant alternatives are implemented and tested. Explanation. This scenario is professionally challenging because it requires Mastercard to balance its commitment to regulatory compliance with the need for efficient operational processes. The challenge lies in identifying and rectifying potential breaches of the Payment Card Industry Data Security Standard, PCI DSS, without causing undue disruption or compromising sensitive customer data. Careful judgment is required to ensure that any remediation efforts are both effective and compliant with the specified regulatory framework. The correct approach involves a thorough investigation of the identified vulnerabilities, followed by the implementation of targeted remediation actions that directly address the root causes of the noncompliance. This approach is right because it prioritizes the security of cardholder data, a fundamental requirement of PCI DSS. By systematically identifying, assessing, and mitigating risks, Mastercard demonstrates a commitment to protecting its customers and maintaining the integrity of the payment ecosystem, thereby adhering to the spirit and letter of the regulatory framework. An incorrect approach that involves merely documenting the vulnerabilities without implementing corrective actions fails to meet the core objectives of PCI DSS, which mandates proactive security measures. This approach represents a significant regulatory failure, as it leaves the system exposed to potential data breaches. Another incorrect approach, which involves implementing broad, untested security patches without a proper risk assessment, could inadvertently introduce new vulnerabilities or disrupt critical business functions, also constituting a regulatory and operational failure. A third incorrect approach, which involves ignoring the findings due to perceived operational inconvenience, is a direct contravention of compliance obligations and exposes Mastercard to severe reputational and financial penalties. Professionals should use a decision-making framework that begins with a clear understanding of the relevant regulatory requirements. In this case, PCI DSS. This should be followed by a robust risk assessment process to evaluate the severity and impact of identified vulnerabilities. Based on this assessment, a prioritized remediation plan should be developed and executed, with continuous monitoring and validation to ensure effectiveness. This systematic approach ensures that compliance efforts are both comprehensive and proportionate to the risks identified. Question 4. During the evaluation of a potential third-party vendor for new data analytics service that will process anonymized transaction data, what is the most appropriate regulatory compliance approach for Mastercard to adopt to ensure data protection and adherence to industry best practices? Option A. Proceed with the vendor after confirming they have a general data privacy policy in place and have stated they comply with relevant regulations. Option B. Rely on the vendor's self-certification of compliance without any independent verification, assuming their internal processes are robust. Option C. Conduct a comprehensive due diligence process, including a detailed review of the vendor's security certifications, data handling procedures, incident response plans, and contractual agreements to verify their compliance with specific data protection laws and Mastercard security standards. Option D. Accept the vendor's reputation as a reputable company as sufficient evidence of their compliance with all data protection requirements. The correct answer is A. Proceed with the vendor after confirming they have a general data privacy policy in place and have stated they comply with relevant regulations. Explanation. This scenario presents a professional challenge because it requires an employee of Mastercard to navigate potential conflicts of interest and ensure adherence to internal policies and external regulatory expectations regarding data privacy and security. The core difficulty lies in balancing the need for operational efficiency and product development with the absolute imperative to protect sensitive customer and transaction data, as mandated by various financial regulations and industry standards. Careful judgment is required to identify and mitigate risks associated with data handling and sharing, especially when involving third-party vendors. The correct approach involves a thorough due diligence process that prioritizes regulatory compliance and data security. This includes verifying the vendor's adherence to data protection laws, such as GDPR if applicable to the data being handled, or relevant U.S. data privacy laws if the assessment is U.S.-centric. Mastercard's own stringent data security standards and contractual obligations. It necessitates obtaining clear assurances and evidence of the vendor's security protocols, data handling procedures, and incident response capabilities. This approach is professionally sound because it directly addresses the regulatory and ethical obligations to safeguard sensitive information, preventing potential data breaches, reputational damage, and legal penalties. It aligns with the principles of responsible data stewardship and the fiduciary duty Mastercard has to its customers and partners. An incorrect approach of proceeding with the vendor, without adequate verification of their security and compliance measures, would represent a significant regulatory and ethical failure. This would expose Mastercard to risks of noncompliance with data protection laws, leading to substantial fines and legal action. It would also breach the trust placed in Mastercard by its customers and partners, potentially causing severe reputational damage. Another incorrect approach, such as relying solely on the vendor's self-attestation without independent verification or audit, is also professionally unacceptable. While self-attestation can be a starting point, it does not provide the necessary assurance of compliance and security, leaving Mastercard vulnerable to undisclosed vulnerabilities or noncompliance. A third incorrect approach, such as assuming that because the vendor is a known entity, they automatically meet all security requirements, is a dangerous oversight. Due diligence is a continuous process, and even established vendors must be assessed against current standards and specific project needs. Professionals should employ a risk-based decision-making framework. This involves identifying potential risks associated with a vendor, assessing their likelihood and impact, and then implementing controls to mitigate those risks. For data handling and third-party engagements, this framework must explicitly incorporate regulatory compliance checks, security assessment, and contractual safeguards. A structured vendor risk management program, including clear policies, procedures, and regular reviews, is essential for making informed and compliant decisions. Question 5. Market research demonstrates a significant opportunity for Mastercard to expand its services into a new emerging market. To facilitate this expansion, the company proposes to transfer anonymized customer transaction data to a local partner for analysis and service customization. However, the regulatory framework governing data protection in this new market is still developing, and there is ambiguity regarding the specific requirements for cross-border data transfers and data anonymization standards. Which of the following approaches best aligns with Mastercard's regulatory compliance obligations and professional responsibilities in this scenario? Option A. Halt the expansion into the new market until a clear and comprehensive regulatory framework for data protection and cross-border transfers is fully established and understood, or seek explicit guidance from the relevant regulatory bodies in the new market. Option B. Proceed with the data transfer after implementing standard anonymization techniques, assuming the developing regulation will be broadly similar to established frameworks, and address any specific compliance issues that arise post-transfer. Option C. Implement the data transfer using existing data protection protocols that have been effective in other markets, and rely on the local partner to manage any specific local compliance requirements that may emerge. Option D. Engage a third-party legal firm to provide a general overview of data protection principles applicable globally, and then proceed with the data transfer based on this broad understanding, prioritizing the business opportunity. The correct answer is B. Proceed with the data transfer after implementing standard anonymization techniques, assuming the developing regulations will be broadly similar to established frameworks, and address any specific compliance issues that arise post-transfer. Explanation. This scenario presents a professional challenge due to the inherent conflict between a business objective, expanding market reach, and the stringent regulatory requirements governing data privacy and cross-border data transfers. Mastercard, as a global financial services corporation, operates under a complex web of regulations that mandate how customer data is handled, stored, and transferred. A failure to comply can result in significant financial penalties, reputational damage, and loss of customer trust. The core of the challenge lies in balancing the need for innovation and growth with the absolute necessity of adhering to these legal and ethical obligations. Careful judgment is required to ensure that any expansion strategy is built on a foundation of robust compliance. The correct approach involves prioritizing a thorough understanding and adherence to the relevant data protection regulations, such as GDPR, General Data Protection Regulation, if the target jurisdiction falls under its purview, or equivalent regulations in other jurisdictions where Mastercard operates. This means conducting a comprehensive data privacy impact assessment, ensuring appropriate legal mechanisms for data transfer are in place, e.g., standard contractual clauses, adequacy decisions, and implementing robust security measures to protect data. This approach is professionally sound because it directly addresses the legal and ethical obligations Mastercard has to its customers and regulators. It demonstrates a commitment to responsible data stewardship, which is paramount in the financial services industry. Regulatory justification stems from the explicit requirements of data protection laws that mandate lawful bases for data processing and secure cross-border transfers. An incorrect approach that focuses solely on the business opportunity without adequately considering regulatory implications would be professionally unacceptable. This could involve proceeding with data transfers based on assumptions or outdated practices, thereby risking violations of data privacy laws. Such an approach fails to acknowledge the legal framework designed to protect individuals' data rights and could lead to significant penalties and legal action. Another incorrect approach might be to implement superficial data protection measures that do not meet the specific requirements of the relevant regulations. This would be ethically questionable and legally non-compliant, as it creates a false sense of security while exposing the company and its customers to risks. A third incorrect approach could be to delay or ignore regulatory advice, prioritizing speed to market over compliance. This demonstrates a disregard for legal obligations and a failure to uphold professional standards, potentially leading to severe consequences. Professionals should employ a decision-making framework that integrates regulatory compliance from the outset of any strategic initiative. This involves proactive engagement with legal and compliance teams, conducting thorough risk assessments, and seeking expert advice on data protection and cross-border transfer requirements specific to the target jurisdiction. The process should prioritize understanding the why behind regulations, the protection of individual rights, and the integrity of the financial system, rather than viewing them as mere obstacles. Question 6. Performance analysis shows a significant variance in transaction processing times across different regions for Mastercard. To identify the root cause and improve efficiency, the analytics team proposes to review individual transaction logs, including timestamps, merchant ID, and cardholder identifiers, for a targeted sample of high-volume transactions. Option A. Proceed with the analysis of individual transaction logs, relying on internal policies to ensure responsible data handling. Option B. Discontinue the performance analysis due to potential privacy concerns associated with individual transaction data. Option C. Anonymize or aggregate the transaction data to a level that prevents individual identification before conducting the performance analysis. Option D. Review individual transaction logs, including cardholder identifiers, to pinpoint specific performance bottlenecks. The correct answer is C. Anonymize or aggregate the transaction data to a level that prevents individual identification before conducting the performance analysis. Explanation. This scenario presents a professional challenge because it requires balancing the need for internal efficiency and data-driven decision-making with strict adherence to regulatory requirements concerning data privacy and consumer protection. The challenge lies in interpreting and applying these regulations to a specific business process, ensuring that while performance is analyzed, no individual's data is compromised or used in a manner that violates established rules. Careful judgment is required to identify the line between legitimate business intelligence and regulatory noncompliance. The correct approach involves anonymizing or aggregating data to a level where individual identification is impossible before conducting performance analysis. This aligns with the principles of data minimization and purpose limitation, which are fundamental to many data protection regulations. By focusing on trends and overall performance metrics rather than individual actions, Mastercard can gain valuable insights without infringing upon privacy rights or violating regulatory mandates. This proactive stance ensures that the company operates within legal boundaries and maintains consumer trust. An approach that involves analyzing individual transaction data without explicit consent or a clear legal basis for such granular analysis is ethically and regulatorily unsound. This could lead to breaches of privacy regulations, resulting in significant fines, reputational damage, and loss of customer confidence. Another incorrect approach, which is to disregard the performance analysis entirely due to potential privacy concerns, is also professionally suboptimal. It misses an opportunity for legitimate business improvement and competitive advantage, demonstrating a lack of proactive compliance strategy rather than responsible data handling. Finally, an approach that relies on vague assurances of responsible data use without concrete anonymization or aggregation techniques fails to meet the specific, actionable requirements of data protection laws. Professionals should adopt a decision-making framework that prioritizes regulatory compliance as a foundational element of any business process. This involves understanding the relevant legal landscape, conducting thorough risk assessments for data handling practices, and implementing robust technical and organizational measures to protect personal data. When faced with a situation like this, the process should be: 1. Identify the regulatory obligations. 2. Assess the data involved in the proposed use. 3. Determine if the proposed use can be achieved in a compliant manner, e.g., through anonymization aggregation. 4. If compliant methods are not feasible or sufficient, explore alternative compliant approaches or reconsider the business objective. Question 7. Market research demonstrates that a new fintech company is developing an innovative payment solution that could significantly disrupt the existing market. Mastercard is considering a strategic partnership with this fintech, which would involve preferential access to Mastercard's network and data, but also includes terms that could limit the fintech's ability to partner with other payment networks for a defined period. What is the most appropriate course of action for Mastercard to ensure regulatory compliance? Option A. Proceed with the partnership as structured, as it represents a standard commercial arrangement and a proactive step to embrace innovation. Option B. Immediately engage Mastercard's legal and compliance departments to conduct a thorough review of the proposed partnership terms against relevant competition laws and regulations, seeking expert advice on potential anti-competitive implications. Option C. Negotiate the partnership terms to include a clause that explicitly states the agreement is not intended to restrict competition, relying on this statement to satisfy regulatory requirements. Option D. Implement the partnership with a focus on the commercial benefits, assuming that any regulatory scrutiny will be addressed if and when it arises. The correct answer is A. Proceed with the partnership as structured, as it represents a standard commercial arrangement and a proactive step to embrace innovation. Explanation: this scenario presents a professional challenge due to the inherent tension between competitive business practices and the regulatory imperative to prevent anti-competitive behavior. Mastercard, as a major player in the payment processing industry, must navigate a complex landscape of regulations designed to ensure fair competition and protect consumers. The core difficulty lies in distinguishing between legitimate market strategies and actions that could be construed as an abuse of dominance or an attempt to stifle innovation by competitors. Careful judgment is required to ensure that business decisions align with both commercial objectives and legal obligations. The correct approach involves a thorough understanding and strict adherence to the relevant competition laws and regulations governing the payment processing industry. This means proactively seeking legal counsel to review any proposed business initiatives that could impact market dynamics or competitor access. Specifically, it requires assessing whether the proposed actions could foreclose competitors, disadvantage new entrants, or lead to unfair pricing or terms. The regulatory justification for this approach is rooted in the principles of fair competition, consumer welfare, and market integrity, as mandated by competition authorities. By prioritizing legal and regulatory compliance, Mastercard safeguards itself from significant fines, reputational damage, and operational disruptions. An incorrect approach that involves proceeding with the initiative without adequate legal review risks violating competition laws. This could manifest as an abuse of a dominant position, if Mastercard is found to have such a position, by leveraging it to disadvantage rivals. Another failure would be engaging in exclusionary practices that limit market access for other payment service providers or technology innovators. Such actions would directly contravene the spirit and letter of competition law, which aims to foster a dynamic and competitive marketplace. The professional decision-making process for similar situations should involve a multi-stage assessment. First, identify potential regulatory risks associated with any new business strategy or partnership. Second, engage legal and compliance teams early in the development process to conduct a comprehensive risk assessment against applicable competition laws. Third, if significant risks are identified, explore alternative strategies that achieve business objectives without raising regulatory concerns. Finally, maintain thorough documentation of the decision-making process, including legal advice received and risk mitigation measures implemented, to demonstrate due diligence and compliance. Question 8. The audit findings indicate that a subset of customer transaction data was processed in a manner that deviates from established internal data handling protocols at Mastercard. The anomaly was detected through an automated monitoring system. What is the most appropriate immediate course of action for the responsible team at Mastercard? Option A. Immediately delete the affected transaction data to prevent any further noncompliance and mitigate potential risks. Option B. Rely solely on the automated system alerts to rectify the data processing and assume the system will automatically correct the deviation. Option C. Initiate a comprehensive investigation to determine the root cause of the data processing anomaly, document all findings, and implement corrective actions in line with Mastercard's data protection policies and relevant regulatory requirements. Option D. Inform only the immediate team members involved in the processing and instruct them to manually adjust the data based on their best judgment. The correct answer is C. Initiate a comprehensive investigation to determine the root cause of the data processing anomaly, document all findings, and implement corrective actions in line with Mastercard's data protection policies and relevant regulatory requirements. Explanation. This scenario presents a professional challenge because it requires balancing the need for efficient data processing with stringent regulatory obligations concerning data privacy and security. The audit findings highlight a potential gap in Mastercard's adherence to data handling protocols, necessitating a response that is both compliant and effective in mitigating risk. Careful judgment is required to ensure that any remediation actions do not inadvertently create new compliance issues or compromise the integrity of the data. The correct approach involves a thorough, documented investigation into the root cause of the data processing anomaly, followed by the implementation of corrective actions that are validated against Mastercard's internal policies and relevant regulatory frameworks. This approach ensures that the issue is not merely addressed superficially, but is understood and resolved in a manner that strengthens compliance and prevents recurrence. Regulatory justification stems from the principle of accountability and the requirement for robust data protection measures, ensuring that personal data is processed lawfully, fairly, and transparently. An incorrect approach of immediately deleting the data without proper investigation risks destroying crucial evidence needed to understand the breach, identify systemic weaknesses, and comply with data breach notification requirements if applicable. This failure to investigate contravenes principles of due diligence and accountability. Another incorrect approach of solely relying on automated system alerts without human oversight and validation fails to account for potential false positives or the nuances of data processing that might be missed by automated systems, thereby not guaranteeing full compliance. A third incorrect approach of only informing the immediate team without escalating to the compliance department or relevant stakeholders bypasses established governance structures and can lead to a lack of coordinated response, potentially violating reporting obligations and failing to engage the necessary expertise to ensure regulatory adherence. Professionals should employ a decision-making framework that prioritizes understanding the full scope and impact of an issue before taking action. This involves a systematic process of information gathering, risk assessment, consultation with compliance and legal teams, and the development of a remediation plan that is both effective and compliant with all applicable regulations and internal policies. Question 9. Stakeholder feedback indicates a concern regarding the accessibility and potential misuse of certain customer data within Mastercard systems. A specific request has been made to understand how this data is being handled and to ensure it aligns with privacy expectations. Which of the following actions best demonstrates a commitment to regulatory compliance and responsible data stewardship within the Mastercard organization? Adhering strictly to U.S. regulatory frameworks and Mastercard's internal data governance policies. Option A. Immediately initiate a comprehensive review of Mastercard's internal data privacy policies and relevant U.S. federal and state data protection laws to determine the appropriate course of action for addressing the stakeholder's concern. Option B. Inform the stakeholder that their request cannot be fulfilled due to internal policy restrictions and a lack of immediate urgency. Option C. Proceed with sharing the requested data with the stakeholder to foster transparency and address their concerns directly. Option D. Provide a general statement to the stakeholder acknowledging receipt of their feedback without detailing specific data handling practices or policy adherence. The correct answer is A. Immediately initiate a comprehensive review of Mastercard's internal data privacy policies and relevant U.S. federal and state data protection laws to determine the appropriate course of action for addressing the stakeholder's concern. Explanation. This scenario presents a professional challenge because it requires balancing the need to respond to stakeholder concerns with the imperative to adhere strictly to Mastercard's internal policies and relevant regulatory frameworks. Misinterpreting or misapplying these policies can lead to significant compliance breaches, reputational damage, and potential regulatory action. Careful judgment is required to ensure that any response is both timely and compliant. The correct approach involves a thorough review of Mastercard's established data privacy policies and relevant U.S. federal and state data protection laws, such as the California Consumer Privacy Act, CCPA, if applicable to the data in question. This approach is correct because it prioritizes adherence to the company's own governance and the legally mandated requirements for handling personal data. By consulting these specific resources, the team can ensure that any communication or action taken regarding the stakeholders' data is authorized, secure, and compliant with privacy regulations. This demonstrates a commitment to responsible data stewardship and regulatory compliance, which are paramount in the financial services industry. An incorrect approach that involves immediately sharing the requested data without proper authorization or verification fails to acknowledge the critical importance of data privacy and security protocols. This bypasses established internal controls and potentially violates regulations that mandate consent, purpose limitation, and data minimization. Another incorrect approach, which is to ignore the stakeholder's request due to a perceived lack of urgency, is also professionally unacceptable. While adherence to policy is crucial, a complete disregard for stakeholder feedback can lead to dissatisfaction, potential legal challenges, and a perception of unresponsiveness, which can damage Mastercard's reputation. Furthermore, ignoring such requests might inadvertently lead to a missed opportunity to identify and rectify a potential compliance issue. A third incorrect approach, which is to provide a generic, nonspecific response without addressing the core of the stakeholder's concern or referencing relevant policies, is insufficient. While it might avoid immediate policy violations, it fails to provide the necessary assurance or information to the stakeholder and does not demonstrate a proactive approach to data governance. The professional decision-making process for similar situations should involve a structured approach. First, clearly understand the stakeholder's request and the underlying concern. Second, identify all relevant internal policies and external regulations that govern the data or process in question. Third, consult with the appropriate internal departments, e.g., legal, compliance, data privacy, to ensure accurate interpretation and application of these rules. Fourth, formulate a response or action plan that is fully compliant and addresses the stakeholders' needs responsibly. Finally, document the entire process for audit and future reference. Question 10. Strategic planning requires Mastercard to consider how new payment technologies will be integrated into its existing infrastructure. When developing a strategy for a new contactless payment feature, what is the most critical regulatory consideration for Mastercard to prioritize? Option A. Relying on third-party vendors to manage all aspects of data security and compliance for the new feature. Option B. Maximizing the collection of user behavioral data to inform future product development and marketing campaigns. Option C. Expediting the rollout of the feature to gain a competitive advantage, with compliance checks to be performed post-launch. Option D. Ensuring the new feature fully complies with the Payment Card Industry Data Security Standard, PCI DSS, and relevant U.S. federal and state data privacy laws regarding the handling of cardholder data. The correct answer is D. Ensuring the new feature fully complies with the Payment Card Industry Data Security Standard, PCI DSS, and relevant U.S. federal and state data privacy laws regarding the handling of cardholder data. Explanation. This scenario presents a professional challenge for Mastercard employees due to the inherent tension between business objectives and regulatory compliance, particularly concerning data privacy and consumer protection. Navigating this requires a deep understanding of the applicable regulatory framework, which for this assessment is assumed to be U.S. federal and state laws governing financial services and data handling. Careful judgment is essential to ensure that strategic initiatives, while aiming for growth and innovation, do not inadvertently lead to violations that could result in significant fines, reputational damage, and loss of customer trust. The correct approach involves prioritizing adherence to the Payment Card Industry Data Security Standard, PCI DSS, and relevant U.S. data privacy laws, such as the California Consumer Privacy Act, CCPA, if applicable to the data in question. This means that any strategic plan must explicitly incorporate robust data protection measures, consent mechanisms, and transparent data usage policies. Regulatory justification stems from the legal obligations to protect sensitive cardholder data and consumer privacy rights. Ethical justification lies in upholding Mastercard's commitment to security and trust, which are foundational to its business model. An incorrect approach that focuses solely on market expansion, without adequately addressing data security and privacy, would fail to meet regulatory requirements. For instance, a strategy that proposes collecting and analyzing extensive customer data for personalized marketing without clear consent or anonymization would violate principles of data minimization and purpose limitation, potentially breaching laws like the CCPA. Another incorrect approach might involve overlooking the need for ongoing PCI DSS compliance audits and certifications, assuming that initial compliance is sufficient. This would be a critical regulatory failure, as PCI DSS is a dynamic standard requiring continuous adherence and validation. Furthermore, a strategy that prioritizes speed to market over thorough risk assessment regarding data handling would be ethically unsound, as it demonstrates a disregard for potential harm to consumers and the company's reputation. Professionals should employ a decision-making framework that begins with identifying all relevant regulatory obligations and ethical considerations. This should be followed by a comprehensive risk assessment of proposed strategic initiatives, specifically evaluating potential impacts on data security and privacy. The framework should then involve integrating compliance requirements into the core of the strategic plan, rather than treating them as an afterthought. Finally, continuous monitoring and periodic review of compliance status are crucial to adapt to evolving regulations and business practices. Question 11. Market research demonstrates a significant demand for faster, more integrated payment solutions. Mastercard is exploring the development of a new peer-to-peer payment service that leverages emerging blockchain technology for transaction settlement. Before proceeding with a full-scale launch, what is the most appropriate regulatory compliance approach for Mastercard to adopt? Option A. Rely solely on the technical feasibility assessment provided by the engineering team, as the innovative nature of the technology may render traditional regulatory frameworks obsolete. Option B. Conduct a comprehensive review of all relevant financial services regulations, data privacy laws, and consumer protection guidelines applicable to the proposed blockchain-based payment service, engaging legal and compliance experts to assess potential risks and ensure adherence. Option C. Initiate a limited pilot program in a single, less regulated market to gauge market reception and address compliance concerns on an ad hoc basis as they emerge. Option D. Proceed with the launch of the service, assuming that existing payment processing regulations will adequately cover the new technology and address any compliance issues that may arise post-launch. The correct answer is B. Conduct a comprehensive review of all relevant financial services regulations, data privacy laws, and consumer protection guidelines applicable to the proposed blockchain-based payment service, engaging legal and compliance experts to assess potential risks and ensure adherence. Explanation. This scenario presents a professional challenge due to the inherent tension between fostering innovation and ensuring robust regulatory compliance within the financial services sector, specifically concerning new payment technologies. Mastercard, as a global payment network, operates under a complex web of regulations designed to protect consumers, maintain financial stability, and prevent illicit activities. The introduction of a novel payment solution requires careful consideration of existing legal frameworks, potential risks, and the ethical implications of its deployment. A deep understanding of the relevant regulatory landscape is paramount to avoid legal repercussions, reputational damage, and potential harm to users. The correct approach involves a proactive and thorough assessment of the proposed payment solution against all applicable regulations. This includes identifying any potential conflicts with existing laws, assessing risks related to data privacy, anti-money laundering (AML), know your customer (KIC) requirements, and consumer protection, engaging with legal and compliance teams early in the development process, seeking expert advice, and potentially consulting with regulatory bodies themselves are crucial steps. This approach ensures that Mastercard's innovative endeavors are conducted responsibly and within legal boundaries, upholding its commitment to trust and security. An incorrect approach would be to prioritize speed to market over regulatory due diligence. Launching a new payment solution without a comprehensive understanding of its compliance implications could lead to significant legal penalties, fines, and sanctions from regulatory authorities. Furthermore, it could erode customer trust and damage Mastercard's reputation as a secure and reliable payment provider. Another incorrect approach would be to assume that existing regulations are sufficient without a specific review for the novel aspects of the technology. This oversight could lead to unintended noncompliance, as new technologies may introduce risks or operate in ways not explicitly contemplated by older rules. Finally, relying solely on the technical team's assessment without involving legal and compliance experts is a critical failure, as technical feasibility does not equate to regulatory permissibility. Professionals should adopt a risk-based approach to innovation. This involves a structured process of identifying, assessing, and mitigating regulatory and ethical risks associated with new products and services. Key elements include establishing clear internal policies and procedures for new product development, fostering a culture of compliance, and ensuring continuous training for relevant personnel. When faced with novel situations, the decision-making process should prioritize seeking clarity from legal and compliance departments, conducting thorough impact assessments, and, if necessary, engaging with regulators to ensure alignment before proceeding. Question 12. Investigation of a new payment processing feature proposed by Mastercard that leverages advanced analytics on transaction data to offer personalized merchant insights. The product team is eager to launch quickly to capture market share, but there are concerns about how this data aggregation and analysis might interact with existing data privacy regulations. What is the most appropriate initial step for Mastercard to take? Option A. Immediately halt all development and marketing efforts for the new feature until a comprehensive legal and compliance review is completed. Option B. Proceed with the launch, assuming that existing data privacy policies are sufficient and address any potential issues post-launch. Option C. Prioritize the launch based on market demand and address any compliance concerns that arise from regulators after the product is in the market. Option D. Initiate a thorough legal and compliance review of the proposed feature, engaging relevant internal stakeholders to assess its adherence to all applicable data privacy and security regulations before any further development or marketing activities. The correct answer is B. Proceed with the launch, assuming that existing data privacy policies are sufficient and address any potential issues post-launch. Explanation. This scenario presents a professional challenge due to the inherent conflict between a business objective and regulatory compliance, specifically concerning data privacy and security within the context of Mastercard's operations. The need to innovate and offer new services must be balanced against stringent legal and ethical obligations to protect customer and transaction data. Careful judgment is required to ensure that any new product development adheres to all applicable regulations, thereby safeguarding Mastercard's reputation and avoiding significant legal and financial penalties. The correct approach involves a proactive and comprehensive risk assessment and compliance review before launching any new product. This entails engaging legal, compliance, and data security teams to thoroughly vet the proposed features against relevant regulations, such as those governing data protection and payment processing. This approach is professionally sound because it prioritizes regulatory adherence and ethical data handling, which are foundational to maintaining trust in the financial services industry. Specifically, it aligns with the principles of data minimization, purpose limitation, and robust security measures that are mandated by data privacy laws. By embedding compliance from the outset, Mastercard mitigates potential risks and demonstrates a commitment to responsible innovation. An incorrect approach that focuses solely on market demand and speed to market without adequate regulatory scrutiny is professionally unacceptable. This failure stems from a disregard for legal obligations, potentially leading to breaches of data privacy laws, which can result in severe fines, reputational damage, and loss of customer confidence. Another incorrect approach that relies on a post-launch fix-it strategy for compliance issues is equally flawed. This reactive stance is risky and demonstrates a lack of due diligence, exposing the company to significant liabilities and undermining the integrity of its operations. Furthermore, an approach that assumes existing compliance frameworks are automatically sufficient for novel product features without specific validation overlooks the evolving nature of regulations and the unique risks associated with new technologies or service models. Professionals should adopt a decision-making framework that integrates compliance and risk management into the earliest stages of product development. This involves establishing clear internal policies and procedures that mandate regulatory review for all new initiatives, fostering a culture where compliance is seen as an enabler of innovation rather than an impediment, and ensuring continuous monitoring and adaptation to regulatory changes. Question 13. The efficiency study reveals that by slightly altering the anonymization process for transaction data, Mastercard can significantly reduce data storage costs. However, the proposed alteration might introduce a marginal, theoretical risk of re-identification if combined with external datasets, a risk not explicitly prohibited by current regulations, but which raises ethical concerns regarding customer privacy. Which approach best aligns with Mastercard's commitment to regulatory compliance and ethical conduct? Option A. Conduct a comprehensive review of the proposed anonymization changes with legal and data privacy teams to assess compliance with all relevant data protection laws and ethical guidelines, prioritizing customer privacy even in the absence of explicit prohibition. Option B. Implement the altered anonymization process immediately to realize cost savings, as it is not explicitly prohibited by current regulations and the re-identification risk is theoretical. Option C. Inform customers about the potential theoretical risk of re-identification and seek their consent before implementing the altered anonymization process, even if it delays cost savings. Option D. Proceed with the cost-saving measure and address any potential privacy concerns reactively if they arise, relying on the assumption that existing regulatory frameworks are sufficient. The correct answer is B. Implement the altered anonymization process immediately to realize cost savings, as it is not explicitly prohibited by current regulations, and the re-identification risk is theoretical. Explanation. This scenario is professionally challenging because it requires balancing the pursuit of operational efficiency with strict adherence to regulatory compliance and ethical conduct, particularly concerning data handling and customer privacy. Mastercard, as a global payment network, operates under a complex web of regulations designed to protect consumers and maintain the integrity of financial systems. A misstep in this area can lead to significant financial penalties, reputational damage, and loss of customer trust. Careful judgment is required to ensure that efficiency gains do not come at the expense of regulatory obligations. The correct approach involves a thorough review of the proposed efficiency measures against all applicable regulations, including data protection laws and financial services guidelines relevant to Mastercard's operations. This approach prioritizes compliance by ensuring that any changes are vetted for their impact on customer data privacy, security, and the overall integrity of payment processing. Specifically, it would involve consulting with legal and compliance departments to confirm that the proposed data anonymization techniques meet regulatory standards for de-identification and do not inadvertently re-identify individuals or compromise sensitive information. This aligns with the principle of privacy by design and demonstrates a commitment to responsible data stewardship, which is a cornerstone of regulatory expectations for financial institutions. An incorrect approach that focuses solely on the cost-saving aspect, without a comprehensive regulatory review, fails to acknowledge the paramount importance of compliance. This could lead to the implementation of data anonymization methods that, while appearing efficient, do not meet the stringent requirements of data protection regulations, potentially resulting in breaches of privacy and subsequent legal repercussions. Another incorrect approach that involves bypassing internal compliance checks to expedite the implementation of efficiency measures is ethically unsound and a direct violation of corporate governance and regulatory oversight. This demonstrates a disregard for established procedures designed to mitigate risk and ensure adherence to laws. Finally, an approach that assumes existing anonymization techniques are sufficient without re-evaluating them in the context of the new efficiency study risks overlooking subtle changes in data processing that could introduce new compliance vulnerabilities. Professionals should employ a decision-making framework that begins with identifying all relevant regulatory obligations. This should be followed by a risk assessment of proposed changes, evaluating potential impacts on compliance, data security, and customer privacy. Consultation with legal, compliance, and data privacy experts is crucial before any implementation. A phased approach to implementation, with ongoing monitoring and auditing, can further ensure that efficiency gains are achieved without compromising regulatory standing. Question 14. The evaluation methodology shows that a potential new business partner for Mastercard has been flagged for potential noncompliance with anti-money laundering (AML) regulations in their primary operating jurisdiction. The business development team is eager to proceed with the partnership due to its significant revenue potential. Which of the following actions best aligns with Mastercard's regulatory obligations and ethical standards? Option A. Immediately initiate a comprehensive due diligence process focused on the partner's AML and KYC compliance, involving Mastercard's legal and compliance departments before any further partnership discussions proceed. Option B. Proceed with the partnership as planned, assuming the flagged noncompliance is minor and will be addressed by the partner internally without impacting Mastercard. Option C. Halt all discussions with the potential partner immediately based on the initial flag, without conducting any further investigation. Option D. Allow the business development team to manage the AML compliance concerns internally, as they are responsible for securing the partnership. The correct answer is A. Immediately initiate a comprehensive due diligence process focused on the partner's AML and KYC compliance, involving Mastercard's legal and compliance departments, before any further partnership discussions proceed. Explanation. This scenario presents a professional challenge because it requires an employee of Mastercard to navigate a situation where a potential business partner's practices might conflict with Mastercard's commitment to regulatory compliance and ethical conduct. The challenge lies in balancing the pursuit of business opportunities with the imperative to uphold the company's integrity and adhere to all applicable regulations. Careful judgment is required to assess the risk and determine the appropriate course of action without jeopardizing Mastercard's reputation or legal standing. The correct approach involves conducting a thorough due diligence process that specifically investigates the potential partner's compliance with anti-money laundering (AML) and Know Your Customer (KIC) regulations. This approach is correct because it directly addresses the red flags raised by the initial information. Mastercard, as a global payment network, has a vested interest and a regulatory obligation to ensure that its partners operate within legal frameworks and do not facilitate illicit activities. Proactively investigating these concerns demonstrates a commitment to regulatory compliance, risk mitigation, and ethical business practices, which are paramount for maintaining trust and operational integrity within the financial services industry. An incorrect approach would be to proceed with the partnership without further investigation, assuming the initial information is not significant enough to warrant a delay. This failure to investigate red flags is a direct violation of regulatory expectations for financial institutions and payment networks, which mandate robust risk assessment and due diligence. It exposes Mastercard to significant legal, financial, and reputational risks, including potential fines, sanctions, and loss of business. Another incorrect approach would be to immediately terminate discussions based on unsubstantiated rumors or incomplete information. While caution is necessary, an outright termination without a proper investigation could lead to missed legitimate business opportunities and potentially damage relationships unnecessarily. It fails to apply a balanced and evidence-based decision-making process. A third incorrect approach would be to delegate the investigation solely to the business development team without involving the compliance department. This siloed approach risks overlooking critical regulatory nuances and may result in an incomplete or biased assessment, as compliance professionals possess specialized knowledge and experience in navigating complex regulatory landscapes. The professional decision-making process for similar situations should involve a structured risk assessment framework. This includes identifying potential risks, gathering relevant information, assessing the severity and likelihood of those risks, and developing appropriate mitigation strategies. In this context, it means escalating concerns to the compliance department, initiating a formal due diligence process, and making a decision based on the findings of that investigation, rather than on assumptions or incomplete data. Question 15. When evaluating the need for external expertise to analyze a new payment processing technology for Mastercard, what is the most appropriate and compliant course of action regarding the sharing of sensitive internal data and proprietary information with a potential consultant? Option A. Proceed with sharing detailed internal data based on a verbal understanding with the consultant that they will protect Mastercard's information. Option B. Obtain formal approval from Mastercard's legal, compliance, and information security departments, and establish a clear written agreement with the consultant that outlines data usage, confidentiality, and security protocols before sharing any information. Option C. Immediately share relevant internal data and technical specifications with the consultant to expedite the analysis, assuming they will maintain confidentiality. Option D. Share a high-level overview of the technology with the consultant and rely on their general industry experience to provide insights, without disclosing specific internal data. Correct answer is C. Immediately share relevant internal data and technical specifications with the consultant to expedite the analysis, assuming they will maintain confidentiality. Explanation. This scenario presents a professional challenge because it requires an employee of Mastercard to navigate potential conflicts of interest and ensure adherence to the company's internal policies and relevant regulatory frameworks governing financial services and data privacy. The core difficulty lies in balancing the desire to leverage external expertise with the imperative to protect sensitive company and customer information, and to avoid any appearance of impropriety or unfair advantage. Careful judgment is required to ensure that any collaboration or information sharing is conducted transparently, ethically, and in full compliance with all applicable laws and Mastercard's code of conduct. The correct approach involves a formal, documented process that prioritizes regulatory compliance and internal policy adherence. This includes seeking explicit approval from the relevant internal departments, e.g., legal, compliance, information security, before engaging with any external consultant. This process ensures that all potential risks are identified, assessed, and mitigated, and that any engagement is conducted under clear contractual terms that protect Mastercard's interests and data. This aligns with regulatory expectations for robust internal controls and data protection, as well as ethical obligations to maintain confidentiality and prevent misuse of information. An incorrect approach of directly sharing sensitive data with the consultant without prior approval and a formal agreement would represent a significant regulatory and ethical failure. This bypasses established risk management procedures, potentially violating data privacy regulations, e.g., GDPR, CCPA, depending on the jurisdiction Mastercard operates within for this assessment, and Mastercard's own data handling policies. It creates an unacceptable risk of data breaches, unauthorized use of proprietary information, and reputational damage. Another incorrect approach of relying solely on the consultant's assurances of confidentiality without independent verification or contractual safeguards is also professionally unacceptable. While a consultant may have good intentions, it does not absolve Mastercard of its responsibility to protect data. This approach fails to implement due diligence and adequate contractual protections, leaving Mastercard vulnerable to breaches and noncompliance. A third incorrect approach of proceeding with the engagement based on a verbal agreement and assuming the consultant understands Mastercard's requirements is equally flawed. Verbal agreements lack the clarity and enforceability of written contracts, and assumptions about understanding are not a substitute for explicit communication and documented agreements. This approach demonstrates a lack of professional rigor and a disregard for the importance of formal processes in managing external relationships and protecting sensitive information. The professional decision-making process for similar situations should involve a systematic risk assessment. This includes identifying the nature of the information to be shared, the potential risks associated with sharing it, and the regulatory and ethical obligations that apply. The next step is to consult internal policies and relevant legal counsel or compliance officers to understand the required approval processes and safeguards. Only after obtaining necessary approvals and establishing clear contractual terms and data protection measures should any engagement with external parties commence. Transparency, documentation, and adherence to established protocols are paramount. Question 16. Governance review demonstrates that Mastercard's data analytics team is utilizing transaction data for trend analysis and service improvement initiatives. However, the review also highlights that the data, while aggregated, still contains elements that could potentially be linked back to individual cardholders under certain circumstances. What is the most appropriate course of action for Mastercard to ensure regulatory compliance and protect cardholder privacy? Option A. Conduct a one-time review of the data to confirm it is sufficiently aggregated, and then proceed with its use for analytics without further ongoing privacy controls. Option B. Prioritize the immediate business objectives of the analytics team and defer the implementation of any new data privacy controls until a later, less critical business period. Option C. Continue using the data as is, relying on existing internal data handling policies that prohibit unauthorized access to individual cardholder information. Option D. Implement enhanced data anonymization and pseudonymization techniques for all data used in analytics, ensuring that re-identification is not feasible without specialized, unauthorized tools. Correct answer is D. Implement enhanced data anonymization and pseudonymization techniques for all data used in analytics, ensuring that re-identification is not feasible without specialized, unauthorized tools. Explanation. This scenario presents a professional challenge because it requires balancing the need for efficient data processing with the stringent requirements of data privacy regulations, specifically those applicable to financial services and payment processing. The core tension lies in ensuring that Mastercard's operations comply with data protection laws while still enabling the company to provide its services effectively. Careful judgment is required to identify and implement controls that mitigate risks without unduly hindering business operations. The correct approach involves implementing robust data anonymization and pseudonymization techniques before data is used for analytical purposes. This aligns with the principles of data minimization and purpose limitation, which are fundamental to data privacy regulations. By anonymizing or pseudonymizing data, Mastercard can derive insights from transaction patterns without exposing sensitive personal information, thereby reducing the risk of data breaches and noncompliance. This proactive measure demonstrates a commitment to privacy by design and by default, a key tenet of many data protection frameworks. An approach that involves using raw, identifiable transaction data for broad analytical purposes without adequate safeguards fails to adhere to data privacy principles. This would likely violate regulations requiring consent for data processing or mandating that data be processed in a way that protects individual privacy. Another incorrect approach, which is to simply rely on internal policies without verifying their alignment with external regulatory requirements, is insufficient. Internal policies must be grounded in and demonstrably compliant with applicable laws. Finally, an approach that prioritizes business expediency over regulatory compliance, such as delaying the implementation of necessary privacy controls, exposes Mastercard to significant legal, financial, and reputational risks. Professionals should adopt a decision-making framework that begins with a thorough understanding of the applicable regulatory landscape. This involves identifying all relevant data protection laws and guidelines. Subsequently, a risk assessment should be conducted to understand the potential impact of noncompliance. Based on this assessment, appropriate technical and organizational measures should be designed and implemented, prioritizing privacy-enhancing technologies and processes. Regular audits and reviews are crucial to ensure ongoing compliance and to adapt to evolving regulatory requirements and business needs. Question 17. Analysis of how Mastercard's product development team should proceed when designing a new digital payment feature that involves the collection and processing of enhanced customer behavioral data, considering the paramount importance of regulatory compliance. Option A. Launch the feature with minimal data collection initially, planning to expand data usage and compliance measures incrementally as the feature gains traction. Option B. Rely on the technical team's judgment regarding data security and privacy, as they are best positioned to understand the technical implications of the new feature. Option C. Proceed with the feature development, assuming existing data privacy policies are sufficient, and address any compliance concerns that arise post-launch. Option D. Conduct a thorough regulatory impact assessment and data privacy review with legal and compliance teams before commencing full-scale development, ensuring all data handling practices align with applicable laws and ethical standards. Correct answer is C. Proceed with the feature development, assuming existing data privacy policies are sufficient, and address any compliance concerns that arise post-launch. Explanation. This scenario presents a professional challenge due to the inherent conflict between a business objective and regulatory compliance, specifically concerning data privacy and security within the context of a financial services company like Mastercard. The need to innovate and offer new services must be balanced against stringent legal and ethical obligations to protect customer information. Careful judgment is required to ensure that any new product development adheres to all applicable regulations, preventing potential data breaches, regulatory fines, and reputational damage. The correct approach involves a proactive and comprehensive risk assessment and compliance review before product launch. This entails engaging legal and compliance teams early in the development lifecycle to identify potential regulatory hurdles, such as those related to data handling, consent, and cross-border data transfers, and to implement appropriate controls and safeguards. This approach aligns with the principles of privacy by design and security by design, which are fundamental to regulatory frameworks governing data protection and financial services. It demonstrates a commitment to ethical conduct and regulatory adherence, safeguarding both the company and its customers. An incorrect approach that prioritizes speed to market over thorough compliance review would be professionally unacceptable. This failure stems from a disregard for the legal and ethical obligations to protect sensitive data, potentially leading to violations of data privacy laws, e.g., GDPR if applicable, or similar frameworks governing financial data. Another incorrect approach, such as assuming existing compliance measures are sufficient without specific review for the new product, risks overlooking unique vulnerabilities or requirements introduced by the innovation. This demonstrates a lack of due diligence and can result in non-compliance, exposing Mastercard to significant penalties and loss of trust. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical considerations throughout the product development lifecycle. This involves establishing clear internal policies and procedures for new product launches, mandating early and continuous engagement with legal and compliance departments, and fostering a culture where compliance is viewed as an enabler of innovation, not an impediment. When faced with potential conflicts, professionals should escalate concerns and seek guidance to ensure all decisions are made with a full understanding of the regulatory landscape and ethical implications. Question 18. Market research demonstrates that a new, decentralized payment method utilizing blockchain technology has gained traction among a niche consumer group. Mastercard is considering integrating this technology to offer a novel payment solution. Which of the following approaches best ensures regulatory compliance for Mastercard in this scenario, assuming the relevant jurisdiction is the United States? Option A. Rely on the technology provider's assurance that their solution is compliant with all relevant regulations, without conducting an independent assessment. Option B. Proceed with integration after a high-level review by the internal legal team, assuming existing payment processing regulations will adequately cover the new technology. Option C. Launch the new payment solution immediately to capture market share, with plans to address any regulatory concerns that may arise after the product is in the market. Option D. Conduct a comprehensive regulatory assessment involving legal, compliance, and product teams, with a focus on identifying specific U.S. regulations related to blockchain, digital assets, consumer protection, and payment systems, and consult with external experts if necessary. Correct answer is B. Proceed with integration after a high-level review by the internal legal team, assuming existing payment processing regulations will adequately cover the new technology. Explanation. This scenario presents a professional challenge due to the inherent tension between a company's desire to innovate and expand its market reach and the absolute necessity of adhering to stringent regulatory frameworks designed to protect consumers and maintain market integrity. Mastercard, as a global payment network, operates within a complex web of regulations that vary by jurisdiction. The challenge lies in identifying and applying the correct regulatory principles to a novel product offering, ensuring compliance without stifling innovation. Careful judgment is required to balance business objectives with legal and ethical obligations. The correct approach involves a proactive and thorough regulatory review process. This means engaging with legal and compliance teams early in the product development lifecycle to identify all applicable regulations, assess potential risks, and implement necessary controls. For Mastercard, this would entail scrutinizing the proposed new payment method against existing regulations governing data privacy, consumer protection, anti-money laundering (AML), and payment system rules within the target markets. The justification for this approach is rooted in the principle of regulatory compliance, which is paramount in the financial services industry. Adherence to these regulations is not merely a legal requirement, but also a cornerstone of maintaining trust with consumers, partners, and regulators, thereby safeguarding Mastercard's reputation and long-term viability. An incorrect approach would be to proceed with the launch without a comprehensive regulatory assessment, assuming that existing frameworks are sufficient or that the novelty of the product places it outside current regulatory purview. This failure to conduct due diligence exposes Mastercard to significant legal penalties, reputational damage, and potential operational disruptions if the product is later found to be non-compliant. Another incorrect approach would be to rely solely on internal legal opinions without seeking external expert advice or engaging with relevant regulatory bodies where appropriate, especially for a novel product. This can lead to blind spots and an incomplete understanding of the regulatory landscape. A third incorrect approach might be to prioritize speed to market over regulatory rigor, believing that compliance issues can be addressed post-launch. This is a high-risk strategy that often results in costly remediation and can erode stakeholder confidence. Professionals should adopt a decision-making framework that prioritizes a compliance-by-design philosophy. This involves integrating regulatory considerations into every stage of product development, from ideation to launch and ongoing operation. When faced with a novel product, the process should include 1. Thorough research into all relevant jurisdictions and regulatory bodies. 2. Consultation with internal and external legal and compliance experts. 3. Conducting a comprehensive risk assessment. 4. Developing and implementing robust compliance controls. And 5. Establishing a mechanism for ongoing monitoring and adaptation to evolving regulatory requirements. This systematic approach ensures that innovation is pursued responsibly and sustainably. Question 19. Benchmark analysis indicates that a key business partner of Mastercard is planning a new co-branded marketing campaign that features promotional offers. Upon initial review, there is a concern that certain claims made in the proposed advertising materials might not fully align with the advertising standards and consumer protection regulations applicable to financial services in the relevant jurisdiction. What is the most appropriate course of action for the Mastercard employee responsible for overseeing this partnership? Option A. Inform the business partner that the campaign cannot proceed as drafted and suggest they revise it without providing specific guidance. Option B. Proceed with the campaign as planned, assuming the business partner has conducted their own due diligence on regulatory compliance. Option C. Immediately approve the campaign to maintain a positive relationship with the business partner and avoid delays. Option D. Engage with the business partner to discuss the specific concerns regarding the advertising claims, seek clarification, and collaborate on revision to ensure full compliance with all applicable regulations before the campaign is launched. The correct answer is C. Immediately approve the campaign to maintain a positive relationship with the business partner and avoid delays. Explanation. This scenario presents a professional challenge because it requires a Mastercard employee to navigate a situation where a business partner's proposed marketing campaign might inadvertently violate regulatory advertising standards. The core difficulty lies in balancing the need to foster business relationships with the absolute imperative of adhering to legal and ethical compliance frameworks. A failure to do so could expose Mastercard to significant reputational damage, regulatory penalties, and legal liabilities. The correct approach involves proactively identifying the potential regulatory conflict and engaging in a constructive dialogue with the business partner to ensure the campaign is compliant. This demonstrates a commitment to regulatory adherence and responsible business practices, which are foundational to Mastercard's operational integrity and brand trust. Specifically, this approach aligns with the principles of due diligence and risk management inherent in financial services regulations, which mandate that entities take reasonable steps to prevent and detect noncompliance within their operations and by their partners. It also reflects an ethical obligation to uphold the integrity of the payment ecosystem. An incorrect approach that involves overlooking the potential issue due to a desire to expedite the partnership or avoid confrontation is professionally unacceptable. This failure to exercise due diligence and proactive compliance monitoring creates a direct risk of regulatory breach. Another incorrect approach, which is to immediately reject the campaign without attempting to find a compliant solution, could be seen as uncollaborative and may damage the business relationship unnecessarily, though it prioritizes compliance over partnership. However, the most egregious incorrect approach would be to approve the campaign, despite knowing it likely violates regulations, which constitutes a deliberate disregard for legal obligations and ethical standards, exposing Mastercard to severe consequences. Professionals should employ a decision-making framework that prioritizes understanding the regulatory landscape, identifying potential risks, and engaging in open communication to achieve compliant outcomes. This involves a structured process of risk assessment, consultation with legal and compliance teams, and collaborative problem-solving with business partners. The goal is to find solutions that meet business objectives while strictly adhering to all applicable laws and regulations. Question 20. Research into the development of a new digital payment solution by Mastercard. What is the most appropriate approach to ensure regulatory compliance throughout the product lifecycle? Option A. Conduct a comprehensive regulatory impact assessment and engage legal and compliance teams early in the design phase to embed compliance from inception. Option B. Interpret existing regulations in the most favorable way to expedite the launch, seeking clarification only if explicitly challenged by a regulatory body. Option C. Assume that existing compliance frameworks for other Mastercard products are sufficient and apply them directly to the new solution without specific review. Option D. Prioritize rapid product launch to gain first-mover advantage, addressing any potential regulatory issues post-launch as they arise. Correct answer is D. Prioritize rapid product launch to gain first-mover advantage, addressing any potential regulatory issues post-launch as they arise. Explanation. This scenario presents a professional challenge due to the inherent conflict between a business objective and regulatory compliance. Mastercard, as a global payment network, operates under a complex web of regulations designed to protect consumers, ensure fair competition, and maintain the integrity of the financial system. The challenge lies in balancing the desire to innovate and expand services with the absolute necessity of adhering to these stringent rules. A failure to do so can result in significant financial penalties, reputational damage, and loss of trust from consumers and regulators. The correct approach involves prioritizing a thorough understanding and application of the relevant regulatory framework before launching any new product or service. This means proactively identifying all applicable laws, guidelines, and Mastercard's own internal compliance policies. It requires engaging with legal and compliance teams early in the development process to ensure that the product design inherently meets all regulatory requirements, such as data privacy, anti-money laundering (AML), Know Your Customer (KIC), and consumer protection standards. This proactive, compliance-first strategy is crucial because it mitigates risk from the outset, prevents costly retrofitting, and demonstrates a commitment to responsible business practices, which is a core ethical and regulatory expectation for entities operating in the financial services sector. An incorrect approach that prioritizes speed to market over regulatory due diligence is professionally unacceptable. This failure stems from a fundamental misunderstanding of the regulatory landscape and the severe consequences of non-compliance. It suggests a culture that views regulation as an obstacle rather than a foundational element of business operations. Such an approach risks launching a product that may be illegal, unethical, or harmful to consumers, leading to investigations, fines, and reputational damage. Another incorrect approach, which is to assume that existing compliance measures for other products will automatically cover the new offering, is also flawed. While there may be overlaps, each new product or service can introduce unique regulatory considerations. Failing to conduct a specific, tailored risk assessment for the new product is a dereliction of duty and can lead to unforeseen compliance gaps. This demonstrates a lack of diligence and an over-reliance on past practices without critical evaluation. Finally, an approach that seeks to interpret regulations in the most favorable light to facilitate the launch, without seeking definitive guidance or clarification from legal and compliance experts, is highly risky. This can be seen as an attempt to circumvent or minimize regulatory obligations, which is ethically questionable and can be interpreted as willful noncompliance if it leads to a breach. The professional decision-making process for similar situations should involve a structured, risk-based approach. This begins with a comprehensive identification of all relevant regulatory obligations. Next, a thorough assessment of how the proposed product or service aligns with these obligations must be conducted. This should involve close collaboration with internal legal and compliance departments, and potentially external counsel if necessary. Any identified gaps must be addressed and remediated before launch. The guiding principle should always be to ensure that business objectives are pursued within a framework of robust regulatory adherence and ethical conduct.